So I think that's probably everyone who was hoping to join us to kick off at 1 o'clock now joining us. So thank you very much indeed for everyone who is joining us today on what I understand is now being called the hottest day of the year for this, our latest Bristol Law Society lunchtime webinar on fire risk assessments at the threshold. My name is Leon Smith and I'm a solicitor at DAC Beechcroft in Bristol, specialising in building and construction disputes, as well as being a council member for Bristol Law Society. And it's in that latter capacity that I am today's nominated responsible person on behalf of the Society. However, I'm delighted to say that I've taken all reasonable steps and used my best endeavours to delegate all immediate and proximate responsibility for today's talk to a far more competent authority. David Sapiecha is a member of Albion Chambers with a wide-ranging practice, including regulatory compliance, professional disciplinary issues, and inquest law. He's also the legally qualified chair of police misconduct hearings. His notable recent cases include a tragic fire in a care home where a service user was not evacuated and died with consideration of relevant obligations under the Regulatory Reform Fire Safety Order 2005. And it's that order, along with the Fire Safety Act 2021, that he will be giving all due and reasonable consideration for us today. If you do have any questions at all, then please do pop them in the Q&A box rather than the publicly viewable chat box, and we can collate those and put those to David at the end of the session. And please also note that we are recording this session and the recording will be available later on Bristol Law Society's YouTube channel.
Thank you very much. Leon, I'm not sure that that introduction is justified and is probably not suitable and sufficient, but there you go. No doubt people will tell me if you can't hear me or if anything goes wrong with the technology. Thank you for attending on this very hot day and welcome. I hope, because I can't see you, but I have a picture in my mind of everyone watching this next to a pool with a pina colada, and that probably is the right way to go about it. Fire risk assessments at the threshold. Why did I choose this to talk about at this time? Because in my view, if they are not already important to you in practice, they may well become important in practice. Why do I say that? There appears to be a greater enthusiasm and momentum in investigating and prosecuting breaches of fire regulations. That's probably partly in response to the Grenfell Tower tragedy and different fire safety organisations waking up to these matters. So consequently, fire risk assessments are being put under a brighter spotlight, and they're beginning to provide extremely fertile ground for lawyers because of challenges and prosecutions that are being brought. The Fire Safety Act of 2021, which came in May of that year, has also brought about, are they changes, are they clarifications, or are they explanations of the main fire legislation, which is the Regulatory Reform Fire Safety Order of 2005. So I'll deal with those changes in due course. The two main statutory provisions, a bit of a mouthful, the first one I've put up there for anyone who doesn't already know about it. So let me begin by going through who needs to carry out a fire risk assessment. So who are the potential clients to the legal industry or potential offenders, or indeed, what are your own responsibilities? Well, Article 3 of the Regulatory Reform Fire Safety Order, or if I just call it the Fire Safety Order, please, says that duties rest on the responsible person. So who is the responsible person? In this order, responsible person means A, in relation to any workplace, the employer, if the workplace is to any extent under his control. So that mirrors general health and safety legislation. So if it's a workplace, it'll be the employer if they have control of the premises. Or B, in relation to any premises not falling within paragraph A, so not a workplace under the employer's control, either the person who has control of the premises as occupier or otherwise, in connection with the carrying on of him of any trade, business or other undertaking, for profit or not. That in itself raises interesting difficulties or interpretation, because it seems to be wider than a lot of health and safety legislation. So possibly it might cover charities, shops, not-for-profit undertakings, enterprises, things such as that. So it's intended to be quite wide. Or the responsible person is the owner, where the person in control of the premises does not have control in connection with the carrying on by that person of a trade, business or other undertaking. The purpose of Article 3 is quite clearly there will be a responsible person. They will be identified and they cannot give up their obligations for being a responsible person. So when things go wrong, there will be somebody who is going to have to bear the brunt of any prosecution. So that's who. What about where? Well, Article 6, among other things, makes it clear that the order, the fire safety order, does not apply to domestic premises. There are exceptions, such as when domestic premises are in a building which has had a prohibition notice served by the fire service. There are other premises which are not covered, which I don't intend to go into today unless anyone really wants me to, but it includes ships, aircraft, etc. So they are the main provisions as to who and where. So the regulatory reform fire safety order says that fire precautions in buildings must be taken. That's the basis of it. And that has to start with the fire risk assessment. Because if one doesn't have an assessment, how can one take the necessary precautions, is the obvious argument. There are some traps in this, because it may be that people who are business savvy, large corporations, local authorities, etc., are up with and aware of all these requirements and may well have whole departments that deal with it. But others are caught who may not expect to be caught. So it isn't now uncommon to find people who rent their homes out on Airbnb to be caught by this and not to have done any fire risk assessment at all. Now, of course, if one rents out one's home at the time that it's being rented out, it is no longer domestic premises. And if people are coming in and renting it, then fire safety precautions are necessary, with all the expense that goes along with it. Sounders, detectors, that sort of thing. So the amateur entrepreneurs are very likely to be caught out. Hotels are quite commonly caught by this legislation. And very often, if somebody buys a hotel and it's an older building, the cost of making it fire safe is something that they put back, and they can be caught out very easily. So a vast number of properties will be caught. Residential care homes. Recently, I was involved in a case that a residential care home was the subject of it. And what is sometimes overlooked is this. The fire safety order requires a fire risk assessment to cover the common parts of the building very often. So if one is dealing, for example, with a block of flats, it is the common parts that will be covered, not the domestic premises. But in a residential care home, that may well include the resident's room if care is carried out in there, and it's not in exclusive possession. Then one has the query with a home such as that, if it is supported accommodation. Is it domestic premises or not? So wide-ranging often goes unnoticed. Blocks of flats are very often the usual areas that attract attention. So the fire regulations cover the communal areas. The Fire Safety Act of 2021 has been passed really for one purpose, to say that if one is looking at the communal areas, the corridors, any storage, etc., fire escapes from the building, where does it end, the communal parts? And the Fire Safety Act of 2021 was enacted to try to clear up the argument. Does it include the doors to the flats and the windows and the walls to the flats? And so the purpose in enacting it was to say, yes, it does. So when carrying out a fire risk assessment of the communal parts, one has to take into account doors, windows, and walls to the domestic premises, even if they are not subject to agreement through the tenancy agreement, etc., that the tenant will necessarily comply with anything that is found from the fire risk assessment. That's, though, quite important now for reasons that I'll come to later, and in case we forget or run out of time, because I think that there's every chance that Article 22 of the Fire Safety Order will be used to try to coerce, encourage compliance from tenants. But looking at the Fire Safety Order, generally, when it came in back in 2006, it changed things dramatically for fire safety. Before that, the responsibility was on the fire service to issue a fire certificate. You got your fire certificate, they would come along and check it, you get another one annually, etc., and you'll be okay. The Fire Safety Order, however, puts the responsibility on the responsible person, often the owner, or certainly the person who has control. So responsibility for the fire safety regime was then on the put on the responsible person. And whilst your fire certificate may have covered adequately the fire safety regime when the building was built, the Fire Safety Order says, no, you have to improve fire safety along with technological advances and modern requirements. And that is quite often what catches hotel owners out if they have an older hotel. The fire service still have a duty to have a regime of checking that responsible persons are carrying out their duties. But it's unlikely to be very extensive. It's usually by way of a fire safety audit, where they will come along and look at one's fire risk assessment to begin with, and that's their starting point, and then see how suitable the fire safety provisions are for a property. As I say, it's not extensive. They can't cover every building. They usually target high-risk properties such as care homes or homes with sleeping accommodation. But they do not take on the responsibility themselves. The responsible person keeps it. So if one is in trouble over fire safety, who are the prosecuting authorities? Well, they're various. The fire and rescue services around the country, or in the capital, the fire brigade, London Fire Brigade. It can include the local authority in some circumstances, but it is usually the fire and rescue service. Remember, if defending matters, that they are subject to the regulator's code under the Legislative and Regulatory Reform Act of 2006. So when enforcing legislation, they have to comply with the regulator's code of encouragement, going in at the right level in terms of enforcement, having an enforcement policy and keeping to it, all those sorts of things, acting fairly and appropriately, basically. Under Article 5 of the Fire Safety Order, and that's 5 subsection 3 and subsection 4, others can also become responsible persons. So under 5.3, any duty imposed by regulations 8 to 22, which are the important ones, the responsible person in respect of premises shall also be, their obligations shall also be imposed on every person other than them who has to any extent control of those premises, so far as the requirements relate to matters within his control, and where a person has, by virtue of any contractual tenancy, an obligation of any extent in relation to the maintenance, repair of any premises, or safety of any premises, they will also be treated as having the obligations of the responsible person. Why is that important? Well, that is used to say that if a company, and this will be another area for clientele, if a company or person carries out a fire risk assessment for the responsible person, they take on the obligations as well and are liable to prosecution if it is not a suitable and sufficient fire risk assessment. I've just put up on the screen a snapshot of the main articles, because it is quite dry reading of the fire safety order. It just sets out the structure. Article 8 is like most health and safety duties. It sets out the general obligations, and then onwards there are specific requirements. Article 9 is a requirement for a risk assessment. 10, the principles to be applied, the hierarchy of safety features. Then Article 11 is the fire, is given effect to the fire risk assessment. So if you have a fire risk assessment, you've got to give effect to it. You've got to put the things in place. Article 12 is fairly obvious. And then it really forms into this. 13, firefighting and detection. So there has to be sufficient detectors, sufficient alarm sounders in the right places, and some firefighting equipment, but generally they don't come into it greatly because it is mainly sufficient fire extinguishers, and most premises have a policy of, if it's a very small fire, you can deal with it that way, but if not, get out. So that's the firefighting detection system, usually having the correct fire alarm enough detectors and automatic detectors and enough sounders so that people are made aware. Article 14 is having and maintaining emergency routes and exits so that evacuation can take place safely. So ensuring that there is compartmentalization of escape routes, so that there is a route out that has at least 30 minutes fire protection around it, no holes in it, no problems with smoke getting through or heat into that area so that people can get out, clear signage, and also ensuring that in panic, maybe in the dark, that there is an easy exit. The final exit needs to be outwardly opening and simple, not looking for a key to get out or something like that. And then Article 17 really is obvious. It's maintaining what you have got there if it is sufficient. Training, the requirements for training, Article 21. The offences are laid out in Article 32. And there is a due diligence defence in Article 33. So it all starts with Article 9, because you have to make and have a suitable and sufficient assessment of the risks to which relevant persons are exposed for the purpose of identifying the general fire precautions you need to take to comply with the order. So there has to be a suitable and sufficient assessment of the risks. The HSE provided guidance for risk assessment some time ago. They say that as long as you make sure that there was a proper check was made, you asked who might be affected, you dealt with the obvious and significant risks and considered the number of people who could be involved, and the remaining risks are reasonable, and you involve your staff or their representatives in the process, then you're on your way to having a suitable and sufficient fire risk assessment. But please bear in mind that those two words are open to a number of interpretations, and they are potentially very wide. I suspect intentionally so that they can be site specific and clear with regard to the dangers, the risks posed by fire, and it's the risk posed by fire in the varied circumstances and properties. So problems can vary often from having no risk assessment at all to having one which is too generic, one which is out of date. So things have changed and it's not been reviewed. Or more commonly now, we're finding, to detailed technical challenges to the fire risk assessment. I start a trial shortly, where I was just looking for documents now, the schedule, and this is just the schedule of those parts which are agreed and those areas of disagreement between the experts. So Scott's schedule is 50 pages, just the schedule, just the headings basically, and a short note. So it is becoming much more common for there to be a detailed and complex attitude to fire risk assessments. So, for example, experts for the prosecution removing door handles to flat front doors to see if there is plastic within them, to see if that's been taken into account in respect to the door furniture, letterboxes, whether they're compliant, and scrutiny of that sort of level. Of course, if one employs 5 or more persons, the fire risk assessment has to be in writing, and it is most common for there to be a fire risk assessor independently involved who then reports to the responsible person. But both can be liable if it is not a suitable and sufficient fire risk assessment. And it's no good for the responsible person just to say, well, I handed it over to them. So what are the arguments and problems with fire risk assessments? One general one, basic one, is when is a fire risk assessment a new fire risk assessment or a version of a previous one? That is now coming up more and more. Is it a matter of different iterations, as a common term being used for fire risk assessments, or is it a new one? My view is, if somebody goes to the premises, even if they've been there before, a year before or whatever, and carries out an inspection and reports and puts in the fire strategy and the significant findings, to my mind, that is a new fire risk assessment. New and independent. It's not so the case if somebody is merely modifying an old fire risk assessment to take into account a particular change. But it is fertile ground for argument. When should fire risk assessments be looked at again? Well, it's quite usual for it to be 12 months, but also if there are significant changes. So in reality, is it still relevant? If it isn't, then it should be looked at again, along with the usual health and safety approach to reviewing things. So planning, doing, and reviewing, maintaining and reviewing. There isn't a specific time limit, which is within the legislation, like there would be, for example, for thorough examinations of lifting equipment. So it is, to my mind, relevance that matters. Qualifications of fire risk assessments. Again, there is no definitive answer. Fire risk assessors quite often pass courses, PAS 79. PAS is publicly available standard. Does that, though, cover specialist areas such as hospitals, care homes, etc.? There doesn't seem to be a definitive answer, and many experts differ in their view, and many experts give quite subjective evidence about fire risk assessments. There is a plethora of guidance and codes of practice, and the adherence and non-adherence to that is often what is argued about, and we are talking volumes of different guidance and codes of practice. What I would say, though, is that generally the approach is that adherence to guidance, just the same as with health and safety law, helps, because if you adhere to it, it's evidence of compliance. If you don't adhere to it, it isn't necessarily evidence of non-compliance. It is if you have dealt with things in a different but equally good way. So I would refer to it as the suitable and sufficiency as a functionality test rather than a prescriptive test. Are things dealt with properly and adequately, albeit in a different way? And they're areas that one often has to look at. British standards are in and around this area as well. Of course, they cannot change the law. They are standards of expectation, but they do not change the requirements of the law, and that is often overlooked. And it's said, well, if you don't adhere to that, you've automatically breached the law. That's not actually right. One has to look at how one has dealt with the situation on the ground. So scrutiny at the moment is pretty detailed. For example, where the windows on an escape route are below 1100 millimeters from the floor, because if they're above, people can crouch and that's acceptable. And what are they made of? So Georgian wired glass was once fine. It's not anymore, particularly unless it has unless it's opaque to stop radiant heat. Things are moving the whole time, and it is difficult to keep up. But the regulations do not require perfection. They allow for tolerable risk. So if by putting a third fire protection door on, one would cut out risk totally, that isn't necessarily what's required if a second door is sufficient. So it is dealing with risk, keeping it to a tolerable level, so a minimum standard to that extent. And there are a growing number of experts willing to give evidence about these matters for both sides. Some are very good, some are quite subjective, and as it's a growing area of litigation, one has to be careful that one gets the right expert who's going to comply with the rules and is talking sense. With regard to the offences, again, this has been a point of argument which may well have to be determined at some point. Article 32 says it's an offence for any responsible person or any other person mentioned in Article 5.3, remember what I said about that, to fail to comply with any requirement or prohibition imposed by Articles 8 to 22. So it's an offence to breach those articles. That is the ensuring that one reaches the standard. So what I would term that as meeting the standard test. If one's fire risk assessment is not suitable and sufficient, then it will fail that. But is that necessarily the end of it? I would say no, because Article 32 goes on to say where that failure places one or more relevant persons at risk of death or serious injury in the case of fire. So to my mind, that is a consequential test, part of the test. You need, in order to have a successful prosecution, in my view, not subjected to any testing yet, a failure to have a suitable and sufficient fire risk assessment, and consequently, that places one or more relevant persons at risk of death or serious injury in case of fire. This is something that is being argued as we speak, and is in a case that I have to come, which I'm defending. But I would say if you fail to take into account some doors that should have been taken into account, but they happen to be fire-resisting doors and all is well with them, and no greater risk is caused by your failure, it might not be a suitable and sufficient fire risk assessment, but it isn't an offence. This is something that is going to, I think, come back again and again, because I know some prosecuting authorities take a different view. So we'll see. I both prosecute and defend these matters. So why did I say we're at the threshold? Well, as I was saying before, the Fire Safety Act of 2021, which has just come in, really was enacted to ensure that it puts beyond doubt that doors, windows and walls to domestic premises, flats within a building, which abut the communal parts or encroaching to the communal parts, are taken into account. And there's a government fact sheet if you have cases around this. The government produced fact sheets, and it says in the case of multi-occupied residential buildings, the Fire Safety Act puts beyond doubt that structure, external walls, flat entrance doors fall within the scope of the fire safety order and need to be included in your fire risk assessment. It does raise the question, well, how do you do that? Because if that's somebody's front door and it's not within their tenancy agreement that they have to give you access, and it's their domestic premises, You're not entitled to barge your way in. There's no getting a warrant or anything of that nature. One possible way which that might be used is Article 22, which has always been in the Fire Safety Order of 2005, may be used. Again, until somebody tries, we do not know. But that says that cooperation can be required from responsible people who share premises. Now, is the flat owner a responsible person in terms of the definition we spoke about before, or not? Well, it might be argued that under 5.4, they have some responsibility for safety in the communal parts. So that may well be the nub of the change. So that when carrying out a fire risk assessment in a block of flats, you can say, the owner can say to the tenant, if they haven't already got it in the tenancy agreement, which one would hope, you need to give us access so that we can see if your doors are fire resistant, if your windows are, or prove to us they are, or if the front doors are not fire resistant, that there's a short area behind the lobby area with fire doors to that lobby, that sort of thing, because one needs the minimum fire protection out, whether it's the front door or it can sometimes be just behind. There may well be other legislation that local authority can use. I don't know, that's not the part of this this discussion at the moment. What about the consequences? Well, if one is convicted of an offence, the Regulatory Reform Act 2001 gives an unlimited fine to a company. So if you're a fire risk assessor company, or an unlimited fine and 2 years imprisonment for an individual. So if it's being run, as often Airbnb are, by individuals, then there's a danger there. The approach to fines is similar to health and safety sentencing guidelines. Those guidelines specifically say they do not apply directly to fire safety. However, they're relevant guidelines which should be taken into account, even though they are not directly applicable under what was 125 of the Coroners and Justice Act 2009. Those watching will know precisely which section of the Sentencing Act that is. I would have to look it up. But also cases such as Crown against Sandhu, S-A-N-D-H-U, and Crown against St Michael's Hospice, Hastings, 2019 EWCA Crim 161, say that whilst the health and safety guidelines do not directly apply, what the judge should do is look at culpability and harm, come up with a possible sentence and check it against the health and safety guidelines to use that as a check to see if he's in the right area. Some might think that's actually using them as a direct guideline. I suppose one takes into account any differences and changes that are applicable. I've put up just on the screen what the Fire Safety Act of 2021 says and where it seems to be going in terms of the threshold. But in reality and in general, fire risk assessments are now needed in a large number of properties and buildings. They've got to be suitable and sufficient. An offence would occur if one didn't carry out a suitable and sufficient fire risk assessment, and that put relevant persons at risk of death or serious injury, subject to any case law that comes about on that. Responsible person cannot abrogate their duties, but others can be involved as responsible persons, and indeed more closely knitted to the team under Article 18, taken on as a consultant to be a responsible person. In my view, these things are going to, these sorts of offences considerations are going to be fertile ground, certainly for, I would have thought, the next few years, as it is under the spotlight and as fire and rescue services start to gain momentum. And we've probably seen a position where they've gone from the easy option of people who have no fire risk assessment to those who've had a fire risk assessment but haven't put in place any fire precautions that were identified within that fire risk assessment, to now having a real battle and scrutiny of fire risk assessments in great detail, and taking on companies that carry them out. And of course, we await with absolute interest the fire safety regulations of 2023, which will come in, I think, January of next year as a result of the Grenfell fire inquiry. A lot of that will relate to high rise. So to provide a fire service, fire and rescue service, or fire brigade, depending where you are, with building plans, information about wall system, external wall systems, cladding, no doubt, details of lifts, etc., to provide the fire and rescue service with details so that they can come up with a fire and rescue plan for those sorts of places. But also any residential buildings with stories over 11 meters in height, they're going to require fire doors to undertake at flat entrances annual checks, and fire doors in common parts quarterly checks. So they're making it more regimented in terms of what is going to be needed. So just to sum up, there are often with this legislation more questions than answers because it hasn't yet been fully legislated, but I think it will be. And it is an area of law which may well become one that you ought to try to get to grips with as soon as possible. That's all that I intend to say about the matter at the moment, subject to any questions that you may have. So I've just seen a question. Fire Safety Act received consent in April 2021, but not yet in force. You're right, it did receive consent in April 2021, but it came in force in May of 2021, 16th of May. So it was wrong on my sheet. It's the 16th of May, but it is in force. I'm going to sit here until somebody tells me what to do.
Well, thank you very much indeed, David, for that certainly most suitable and more than sufficient briefing on the SFO and the recent Fire Safety Act. We did also have another question in relation to the dates that the order itself came in force. Now, I should say we have had, very grateful for a correction, a message come in about the marketing material for this particular webinar, which referred to the Fire Safety Act 2006. I assure you that was something that was wrong on the marketing material. It is, of course, the Fire Safety Order 2006. The Act is the 2021 Act. But in terms of a question, I understand that the order referred to coming into force on the 1st of April 2006. But David, there was subsequently, I think, a statutory instrument bringing certain provisions into force on the 1st of October.
It's October.
2006.
It runs from October. The Act was in April, but yes, it was delayed until October. But hopefully there's not going to be anything that's going to turn on when that was in. It was October 2006.
Thank you very much. And so is it correct, I think, that there are some provisions possibly of the Fire Safety Act, which, although the Act itself is in force, the provisions don't necessarily apply until January 2023? And if correct, to what extent will the courts, do you anticipate, have regard to elements of that Act prior to those particular bits perhaps being enforceable?
It will be, as I say, it's the fire, I forgot what they're called now, the fire safety regulations of 2023 that are going to come in force. It is interesting because we've had arguments already about the Fire Safety Act and the doors and whether one looks retrospectively at fire risk assessments before the Fire Safety Act came in. Prosecutions recently have been trying to say, well, Fire Safety Act wasn't in, therefore it's irrelevant. We have argued, well, it might be irrelevant, but the fact that it came in wasn't just to explain the provisions of the regulatory reform order. It was basically to change it, to say it covers the doors, etc., and that you didn't need to do it beforehand. And so you will get arguments like that. But generally, other than the path that the law is taking to show whether your argument is correct or not at a particular time, it shouldn't be, in my view, it shouldn't be a standard that's coming in set before it comes in. That is not how it generally works.
Thank you very much. And finally, with I think specific reference probably to ultimately Article 9 of the Fire Safety Order and the requirement for the fire risk assessments for relevant premises. We've had one question specifically about, for example, volunteer-run premises such as sports facilities. So without actual employees from an employment law point of view, but looking at things such as changing rooms or shower blocks, or even privately owned toilets, but which are open to the public. Does the requirement bite that all of these premises should have their own fire risk assessments?
Okay, that's quite a very good question, actually. We do get some help because Article 25 sets out the enforcing authority. So generally it's the Fire and Rescue Service. It can be the Health and Safety Executive. So if it's a workplace, and the usual rules apply over that, if somebody's working there, yes, and it's the Health and Safety Executive who will prosecute. But the relevant local authority would be the enforcing authority in relation to premises which consists of a sports ground designated as requiring a safety certificate under Section 1 of the Safety of Sports Grounds Act 1975. Now, I don't know what needs that, but that's the test. So it's Article 25. That sounds to me as though it's probably some sort of stadium. Or a regulated stand within the meaning of Section 26(5) of the Fire Safety and Safety of Places of Sport Act. So safety certificates for stands at sports grounds. Again, I suspect that is a commercial one after the Hillsborough tragedy. So it is interesting. It depends whether, if one looks at so sports arenas are covered. It depends on the nature of it. The test is, if it's not a workplace, is it in connection with the carrying on by him of a trade, business, or other undertaking for profit or not? And undertaking in the general English terms means carrying out of a task, etc. I think it's one of those where one would have to look at it quite deeply in terms of sports changing rooms, etc. And the nature of what's going on there.
Thank you very much. I don't think we've got any more questions coming through. No, we do. So one of our guests has said a fire risk assessment, yes, but not recorded as technically no employees.
There you go.
Seems to be their view. If there's any other questions, please do speak now. Otherwise, thank you very much indeed to David for your talk today, and thank you very much for all of our attendees and those of you who've prompted these fascinating questions.
Thank you very much.